very important that you know how to handle a notice of intent to deny so that you're not placed in removal proceedings, friends, because the stakes are that high. This notice, friends, is very serious. It's sent from USCIS, typically to the petitioner of a case, a green card case, and it is also sent to individuals who are going through a naturalization citizenship process, as well as others who are going through an employment-based process. It is the government's way of communicating with you that they intend to deny this case based on some very serious findings. Some of those findings are sometimes wrong. Other times, those findings are accurate, and they expect you to address those allegations that they have. And these allegations against an individual typically comes up after they filed their case. They've been interviewed by USCIS, and either during the interview, something came up that caused the government to pause and to say, wait a minute, we've got to look further into this matter. We've got to dive a little deeper into this problem. So let's do an investigation or further background checks. And then after the background check, has been done, they'll draft a letter and outline for you what additional problems they found with your case. Or other times they would send you this notice of intent to deny your case based on just what they see on paper alone, based on discrepancies in the record regarding your facts. It could be maybe inconsistent information that was on a visa application or a green card application. And certainly they drill down in marriage cases if they think or believe that you've been part of marriage fraud. They would send this notice of intent to deny and expect you to address their problem. One thing that you should know with the notice of intent to deny, friends, is that you've got to pay very close attention to who it is addressed to. Is it addressed to the petitioner, or is it addressed to the beneficiary? Like I said, most times it's addressed to the petitioner, but there are times, of course, depending on the application, that it is addressed to the applicant. Only that person can respond to this. So, for example, and this is a very, very common thing in marriage cases, if they send the notice of intent to deny to the petitioner's spouse for the I-130, arguing that they think that the marriage is not genuine. They think that it's not bona fide. And so they're expecting the petitioner's spouse to respond to it, while the beneficiary wife or husband isn't supposed to respond to it.